Good morning, everyone. I'm pleased and honoured to be here. I only have 20 minutes, so I'm going to crack on. No distracting charts, so pin your ears back. 2,400 years ago, Aristotle, that's what we're going to talk about at 9 o'clock in the morning, wrote in his Politics about monopoly. He said, people had been saying to Thales that philosophy was useless as it had left him a poor man. But he, deducing from his knowledge of the stars that there would be a good crop of olives while it was winter, raised a little capital and used it to pay deposits on all the olive presses in Miletus and Chios. Then the time of the olive harvest came, and as there was a sudden and simultaneous demand for olive presses, he hired them out at any price he liked. The way to make money in business is to get, if you can, a monopoly for yourself. That was Aristotle. This is what I want to say. The UK's opt-out regime, the child created 10 years ago by the Consumer Rights Act, is alive and functioning well. It's not perfect. What is? It's still only an adolescent, but it works and we must cherish it. I'm going to spend my time explaining why I think that is the case. And I'm speaking after the Civil Justice Council review of litigation funding, and whilst we await the results of the UK Department for Business and Trade's consultation on the working of the regime. And since the Competition Appeal Tribunal's judgment in Gutmann versus LSER and others, and Kent v. Apple. Of course, over the next 2 days, you'll be discussing global class actions. And so what I'm going to talk about, and what my very limited experience covers, is a very small part indeed of that world. It is also, by the way, quite a small part of consumer redress, even in the UK. Nevertheless, that's where my experience lies, and I think the reason I'm here is because this small world is quite important to a lot of people inside and outside the UK at the moment. Actually, this regime formed quite a small part of the 2015 CRA, almost an afterthought. It can be viewed as an attempt to privatise some consumer redress and enforcement, to take it out of the hands of state organisations like regulators, ombudsmen, the CMA, Citizens Advice, itself an arm's-length government body operating as a pseudo-charity, trading standards, etc., and put it in the hands of lawyers and litigation funders, of course, which a genuine consumer membership organisation, plays an important role in both monitoring consumer harm and campaigning for redress, and is also playing an important role under this regime. I should make it clear that I'm not talking about high-volume consumer claims such as Dieselgate, the subject of the Solicitors Regulation Authority consultation, which ends today. I have characterised seeking redress under this regime as drinking in the last chance saloon, the last chance to right a wrong when all else has failed. The market itself, exhortation, regulation, and most importantly, consumers themselves. Typically under this regime, many thousands, even millions of consumers who may be unaware of the harm done to them individually, which may be quite small, and even if they are aware, may not understand the harm clearly and understand even less well the redress opportunities open to them. And it is for these reasons that the regime was created. But it was not simply about redress, about recompensing consumers for the harm done to them, but also about stopping the bad market behaviour of powerful actors, thus helping markets and hence choice for consumers and fairness to all market players to function effectively. Competition depends on consumers being able to make choices, which in turn requires that consumers are able, knowledgeable, and willing to do so. But as we know, especially since the Citizens' Advice conducted groundbreaking research on this in 2015 into consumer priorities, consumers do not have the time, the inclination, or the knowledge to make good, rational choices, a situation known to businesses and advertisers since time immemorial. So ripping off consumers, done maliciously or not, with knowledge or not, is baked into consumer society. Let's just pause a moment to reflect on that sweeping assumption. Wish and Bailey, amongst many, set out very clearly the theories of competition underpinning most global competition regimes, including the question of monopoly and dominance. So the old canard of the Chicago school, that if a successful competitor, by means of its efficiency, innovation, cheapness, customer service, etc., becomes dominant, it should not be punished simply for being successful. Quite. But it can and should be punished for abusing that dominance to harm consumers. Wish and Bailey also remind us that Schumpeter said short-term monopoly power need not cause concern because a perennial gale of creative destruction would be sufficient to protect the public interest. So in some market-based economies, dynamic efficiency may be more important than allocative and productive efficiency. But what is the short term? And what happens to consumers during this short period? This is implicitly what the MAGA companies rely on: Microsoft, Apple, Google, Alphabet, or alternatively the Magnificent Seven, who collectively represent more than a third of the S&P 500 index. But of course, that does not stop me and other class representatives from holding them to account anyway, and there is no provision in the 1998 Chapter 2 prohibitions or subsequent legislation in the UK that would give force to Schumpeter's argument. Which brings us nicely to the growth of litigation in this sphere. So in the 10 years since October 2015, when the Act came into force, there are about 31 substantive cases, 13 of them against MAGA, of which 28 have been certified. Actually 29, because I was certified last week. The value of claims is some 160 billion, covering some 650 million class members. In my view, a relatively small number of cases that have accumulated over 10 years and an unsurprising value of claims, especially bearing in mind the number of consumers affected and the historical reach of many claims. Actually, Brattle recently showed that there's been a drop in the number of claims coming forward this year. However, it is not really an uninterrupted 10 years at all, but 5 years since the Supreme Court decision in Merrick's that allowed the stalled regime to move on. So why the surprise of the DBT about this growth in its call for responses to consultation? Could it be linked to the claim made by the so-called European Centre for International Political Economy and bandied about by the oddly named Fair Civil Justice, that these collective actions drain the UK economy of 18 billion, a nonsense debunked by Beverly Robertson of the Class Representatives Network in her paper, Do Class Actions Really Harm the UK Economy? No. Let's turn to how our child developed and why at 10 years old there is still quite a way to go to maturity. Of course, its development was interrupted by Brexit, COVID, and the recognition that the digital platforms had the data assets, market share, and regulatory free rein to develop in the way they did. But these were the kind of hurdles that any healthy child should take in its stride. The framework which we deal with is the CRA itself, the Competition Acts, the Civil Procedure Rules, the CAT rules, and evolving case law. This last, the essential sinews of any developing child, is the key to both why I said in my opening remarks that the child is growing as expected, but there is still some way to go. And it is also part of the explanation for why my Boundary Affairs case, the first standalone case under the regime, filed in 2019, has only recently ended. So on the one hand, a naive observer might say, this is outrageous. But on the other hand, a closer look says, this is the inevitable result of a case filed at the early development of the regime and consequently subjected to the delays caused by waiting for decisions of the CAT, the Court of Appeal, and the Supreme Court. So, for example, Boundary Affairs was delayed for a year whilst we waited for the outcome of the Merrick's appeal to the Supreme Court. My good friends at Charles Linden, solicitor in all three of my cases, have identified 18 important CAT and COA rulings and judgments relating to certification, costs and funding, and settlement. I don't have time to go through them all now, and anyway, many of you will no doubt be familiar with them, but I will mention Hammond v. Amazon, carriage disputes to be resolved as a preliminary issue independent of certification, Reefer v. Apple, clarification, development of CR's heavy responsibility, CA v. Qualcomm, cost-benefit analysis following Gutmann, Neil v. Sony, first certification post-PACCAR, certainty that cases remain fundable. Gutmann v. First MTR and others, second collective settlement approval order with significant implications for future settlements. All these, and there will be more, have been partly driven by defendants' strategies of delay. This is therefore an example of the unintended consequence of an action, as I am sure it was not the defendant's intention to develop, strengthen, and clarify the regime. In so doing, they have rendered the cause of consumer redress and market strengthening an incomparable service for which we must all be grateful. They have, of course, delayed matters considerably and racked up costs. Que sera, sera. Turning to funding, I am and have always been opposed to lawyers and funders getting paid a proportion of damages. It is right that class members should shoulder some of the costs from their damages, but that should be based on the actual costs rather than an arbitrary proportion. But, and it is a big but, as the report produced for me by Crescent to help in the SSWT settlement hearing showed, and as the CAT has repeatedly confirmed, funders must get paid for their investment, and lawyers on CFAs for theirs too. They must get paid according to the amount of capital at risk, the level of risk, and the length of time the capital is deployed. As the report showed, the central problems are the binary nature of the risk, the initial uncertainty around the time frame, and the high cost of expertise in managing litigation assets. Far be it from me to weep crocodile tears over the problems faced by funders. However, as someone who's been involved directly with 3 funders over a number of years and who has observed the evolution of the regime and its funding, I must say that recent criticism of the investment funding industry has been grossly ill-informed. Yes, I welcome the CJC recommendations on the regulation of this important market, but we must all recognise that whether funders are characterised as a necessary evil or just necessary, without them there is no regime. The idea of government funding however arm's length it might be, is simply ludicrous in the present political era. So the problem remains, how can the CAT ensure fairness in managing funder and other returns when in general portfolio losses, negative returns, have to be offset by large returns on wins? I commend the Crescent report to you. I want to say a few words about distribution. Putting money back in consumers' pockets, money wrongfully taken from them, a tangible symbol of redress in action. Sadly, thus far, there hasn't been much, and largely for reasons I have already discussed. And so what has happened does not provide much guidance for the future, when there will be much more, but does provide some pointers. Unfortunately, in the UK, we are reliant on large US-based distributors with Angion and Epic at the forefront. These have tremendous experience in the US jurisdiction and large process-driven staff. They have little experience in the UK market and do not have a clear understanding of the UK's social conditions and attitudes, nor a detailed knowledge of and relationships with the UK comms market. No doubt both of these disadvantages will become overcome over time. Successful class actions or settlements offering small returns to individual class members may also suffer, as my boundary affairs did, from historical uncertainty. And this will be a problem when and if the issue of going back in time prior to 2015 is sorted out. Where defendants do not hold customer records, again in my boundary affairs settlement, there exists the problem of actually finding class members. Where customer records exist, however problematic, this is a great advantage, as we shall see in Kent v. Apple. The concept of these types of class actions is a new one in the UK, so consumers are not, as in the US, open to stepping forward to claim. They are suspicious, put off by lengthy, time-consuming processes, and worried about parting with personal information, especially bank details. A rueful commentary on the success of scam awareness campaigns and another reminder of consumer priorities I have already referred to. So all parties to the distribution have to be agile and comms budgets have to be robust. And when distribution is disappointingly low, there is then the opportunity to make a donation to charity, such as Access to Justice, as a proxy for claimants, as was successfully done in my Stagecoach settlement. It would be churlish of me not to say something about class representatives. We are a very mixed bunch: lawyers, policy wonks, ex-regulators, economists, ombudsmen, and campaigners. Oh, and rock band drummers. But we all have a passion for putting consumer wrongs to right. There was little guidance at the outset of the regime as to what qualification a class representative should have, or a detailed description of the duties involved. So the role has evolved, and that evolution has been assisted in three main ways. The early establishment by Walter Merricks, Mark McLaren, and Kate Wellington of the Class Representatives Network, learning on the job, and the reefer judgment. I want to see training provision developed for PCRs, CRs, as our responsibilities grow and the regime develops. Before I conclude, I want to say a few words about the CAT itself. We have a new president in the Honourable Mrs. Justice Bacon, and we have a distinguished panel of chairs and of members. Anyone who has seen them in operation will know that they bring immense skill, knowledge, and experience to the cases which they hear. And they are supported by a cadre of excellent staff. But I'd raise two questions, especially given my own experience on boundary affairs. Do we have sufficient personnel, and do we have sufficient space? So, to conclude, It is true that the regime has taken a long time to evolve, and we still have some way to go to a steady state with a clearer idea for defendants, litigants, and funders in particular of how long things are going to take and what can and cannot be done. But I think we've made enormous strides. The CPO process is tough, fair, and robust, so that only cases that have clear merit proceed. Appeals have generally been unsuccessful or have strengthened and clarified the regime. There have been few, if any, strikeout summary judgments, which shows that the pre-application process is also working well. So it is unfair, as the extreme right claim, that dominant corporations are held to a higher standard than the hairdresser down the road. Of course not. Where do we go from here? Do we abandon the privatization experiment, as I've called it, and revert to the state apparatus for consumer redress? Do we bend to the will of the right and either abolish the whole regime or clip its wings by making the C application process even more difficult? This might happen if the government is cowardly and the current DBT consultation process is used to provide the cover for giving in to pressure from UK big business, US global players, and their advocates. But I and my fellow CRN members, on behalf of the consumers we represent now, and those we know for sure will need representing in future, demand that this child that has been so successfully nurtured over the last 10 years, as I've tried to show, continues to be supported and nurtured to bring it to full maturity, so that the UK can be proud that in one small area of consumer redress, it does actually have something about which it can truly be said that we have global leadership. To do that, we all need to stand up and be counted. Enjoy your conference. Thank you.